Hello, and welcome to another episode of TacoBytes, your daily bite of Degen, episode number 714, coming to you live from somewhere nowhere, Dallas, Texas. It is a good day for many reasons. One of the main reasons we're talking about today is Judge Torres' ruling on the SEC versus Ripple, or properly Ripple versus SEC case that has been going on for a little while now. And this ruling is a motion for remedies that the SEC filed. And so I thought the easiest way, having gone through it real briefly, but to go through it line by line with you, break that down, have a little fun, reading on, this is going to be reading with Taco, basically. None of there's no fun stuff with that, other than getting a little bit of some law on this. And, so it is going to be, let's see here. We need to get the right screen up because that one screen just doesn't look right when it's being shared. So we're going to go with the right screen. Boop. Got it. Added to stage. There we go. So if you want this, we are going to put this out there. This is huge thanks to Jim Flan for dropboxing this out to everyone. And really sort of appreciate that. So Annalisa Torres, district judge, plaintiff, the Securities and Exchange Commission, the SEC, brings this action against defendant Ripple Labs, also known as Ripple, alleging that Ripple engaged in the unlawful offer and sale of securities in violations of Section 5 of the Securities Act of 1993, 15 USC 77, and Compliance 9, 430 through 35, ECF number 46. On July 13th, the court granted in part and denied in part the parties' cross motions for summary judgment, the order. So this was last month. And so this, the parties' cross motion for summary judgment, order ECF number 874. Motion to certify appeal denied. Now before the court is the SEC's motion for remedies and the entry of final judgment. SEC motion number 948 and 949, proposed judgment 950. For the reasons stated below, the SEC's motion is granted in part and denied in part. So background section will go over what all of these things sort of were. This case involves the defendant's offer and sale of XRP, the native digital token of the XRP ledger, a cryptographically secured ledger or blockchain. In order to, on December 22nd, 2020, and we're going to read footnotes at the end. The SEC commenced this action. An amended complaint was filed on February 18th, 2021. As relevant here, the SEC alleged that Ripple engaged in 3 categories of unregistered XRP offers and sales. Institutional sales, underwritten contracts for which it received $728 million. Programmatic sales on digital asset exchanges for which it received $757 million. And other distributions, underwritten contracts for which it recorded $609 million in consideration other than cash. The SEC also alleged that Bradley Garlinghouse and Christian A. Larson, 2 of Ripple's senior leaders, engaged in unregistered individual XRP sales from which they received at least 450 million and 150 million respectively. Under Section 5, respectfully received. That's a good one. Under Section 5 of the Securities Act, it is unlawful for any person, directly or indirectly, to offer to sell, offer to buy, or purchase or sell a security unless a registration statement is in effect or has been filed with the SEC as to the offer and sale of such security to the public. To prove a violation of Section 5, the SEC must show, 1, that no registration statement was filed or in effect as to the transaction, and 2, that the defendant directly or indirectly offered to sell or sold the securities through interstate commerce. SEC versus Kavanaugh. At summary judgment, the court, applying the Supreme Court's test set forth in the SEC versus Howey, 1946, concluded that Ripple's institutional sales constituted offer or sales of investment contracts, but that Ripple's programmatic sales and other distributions did not. At Order 30, the court also held that Larson and Garlinghouse's individual sales were not offers or sales of investment contracts for substantially the same reasons, stating the court's analysis of Ripple's programmatic sales. The SEC subsequently moved to certify for interlocutory appeal the court's holdings on programmatic sales and other distributions. On October 3rd, the court denied the SEC's motion and set for trial the SEC's claim that Larson and Garlinghouse aided and abetted Ripple's violations of Section 5 with regard to the institutional sales. By stipulation dated October 19, 2023, the SEC dismissed its pending claims against Larson and Garlinghouse, obviating the need for a trial. Now before the court is the SEC's motion for remedies and entry of judgment on Ripple's violations of Section 5 as to the institutional sales. The SEC seeks a final judgment against Ripple that, 1, permanently enjoins it from future violations of Section 5 and from conducting an unregistered offering of XRP in institutional sales. 2, orders Ripple to pay $876 million in disgorgement and $198 million in prejudgment interest, and that orders Ripple to pay an $876 million civil penalty. What that is? $1.7 billion, roughly. Whew. Ripple contends that an injunction and disgorgement are unwarranted and that any civil penalty should not exceed $10 million. Ripple gave a really good argument of why that should be the case. Once a district court has found federal security law violation, it has broad equitable power to fashion appropriate remedies. Such remedies may include injunctive relief, disgorgement of ill-gotten profits, and civil penalties. The SEC asks for all 3. Injunctive relief, legal standard. Injunctive relief is expressly authorized by Congress to proscribe future violations of federal security laws. SEC versus Kavanaugh. Such relief is warranted if there is a reasonable likelihood that a defendant will commit future violations of the securities law. So we'll go. Yeah, we're going to read through this all because it's real short. It's 16 pages, and then we'll break back down through all of it. SEC versus M growth funding, citing SEC Commonwealth. To award injunctive relief, a court must look beyond the mere facts of violations to a realistic likelihood of recurrence. To determine whether injunctive relief is appropriate, courts are directed to consider 1, the fact that the defendant has been found liable for illegal conduct. 2, the degree of sentier involved, whether the infraction is an isolated occurrence, whether a defendant continues to maintain that his past conduct was blameless, and 5, whether because of his professional occupation, the defendant might be in a position where future violations could be anticipated. The SEC asks the court to enjoin Ripple from violating Section 5 and from conducting an unregistered offering of institutional sales of XRP. Ripple argues that the SEC has failed to show that an injunction is warranted. The court agrees with the SEC. As to the first and third Kavanaugh factors, Ripple has been found liable for violating Section 5 in its sales of XRP to institutional buyers. These violations were not isolated. They spanned 8 years and involved 41 counterparties. Offenses not when they involved 13 clients over the course of 3 years. On the second Kavanaugh factor, the degree of scienter, the SEC contends that Ripple's violations involved at least a reckless disregard for the law. The SEC notes that in February 2012, before XRP Ledger was publicly launched, Ripple received a memorandum from Perkins Coie LLP law firm advising that if it sold to investors, XRP tokens are likely to be securities. Order 7 cleaned up a subsequent Perkins Coie memorandum counseled that although we believe that a compelling argument can be made that XRP tokens do not constitute securities under federal security laws, given the lack of applicable case law, we believe that there is some risk, albeit small, that the SEC disagrees with our analysis. The law firm also advised Ripple that the more it promoted XRP as an investment opportunity, the more likely it is that SEC will take action. Larson testified that after receiving the second Perkins Coie memorandum, Ripple took steps to ensure compliance with its advice. At summary judgment, the court found that a genuine issue of material fact remained as to whether Larson's and Garlinghouse had recklessly disregarded the securities law. Because the SEC had added no new facts to support a finding of recklessness at this stage, the court finds that Ripple's Center 2 is inconclusive. SEC versus Haligonis. Collecting cases imputing the center of a corporate agent to the corporation. Although this SEC points to Ripple's profit motive to avoid registration and disclosure, this fact alone does not support an inference that Ripple recklessly disregarded regulatory requirements in making its business decisions. Noting that in common law fraud context, the profit motive common to all businesses is insufficient to establish center. I feel like that's just a fancier word for motive. Now, on the fourth Kavanaugh factor, the defendant's willingness or unwillingness to accept blame, the SEC points to a number of post-order statements made by Ripple and its corporate agents to argue that Ripple has not accepted responsibility for its violations. Ripple in turn notes that it has acknowledged the court's ruling on the institutional sales in each of its quarterly market reports and contends that the other cited statements are taken out of context. Having considered the post-order statements, the court does not find that Ripple has continued a campaign of deflecting blame. Although Ripple and its employees have largely emphasized the favorable aspects of the order in their public statements, Ripple has also repeatedly acknowledged the court's holdings as to its institutional sales. Ripple's post-order statements do not rise to the level of blame shifting required to justify injunctive relief based on this factor alone. Citing defendants' continued protestations that his conduct was blameless. Ripple's actions, however, are another story. Relevant to the fourth and fifth Kavanaugh factors, the SEC asserts that Ripple's continue to sell XRP unregistered to institutional buyers, specifically in continuing to execute contracts for unregistered sales of XRP in direct, on-demand liquidity transactions. Ripple admits that after the order was issued, it has continued to sell XRP in ODL transactions. It also concedes that the order defined institutional sales as including sales to ODL customers. Okay. However, Ripple argues that its ongoing ODL sales do not have the key characteristics that this court relied on in finding that Ripple's institutional sales were sales of investment contracts. Not so. Although the court noted that some institutional buyers agreed to lock up provisions or resale restriction features inconsistent with the notion that XRP was used as a currency or for some other consumptive use, the court did not hold that a contract lacking these features is ipso facto lawful under Section 5. Order at 2122, emphasis added. Ripple attempts to re-litigate the court's inclusion of ODL transactions in institutional sales, while at the same time suggesting that Remedies briefing is not the time or place to analyze the ODL transactions in detail. The company cannot have it both ways. To be clear, the court does not today hold the Ripple post-complaint sales have violated. Does not today hold that Ripple's post-complaint sales have violated Section 5. Rather, the court finds that Ripple's willingness to push the boundaries of the order invites a likelihood that it will eventually, if it has not already, cross the line. On balance, the court finds that there is reasonable probability of future violations, meriting the issuance of an injunction. Turning to the scope of the injunction, Ripple first contends that Part 1 of the SEC's proposed judgment, which permanently restrains and enjoins Ripple from violating Section 5 of the Securities Act, proposed judgment at 2, is an unhelpfully vague directive not to violate the law. But the Second Circuit has found that an injunction that merely parrots statutory language is proper. Okay. Courts in this circuit routinely impose such injunctions in securities cases. Ripple also argues that Part 2 of the proposed judgment, which enjoins it from conducting an unregistered offering of institutional sales, proposed judgment at 3, should be altered to clarify that it does not bar ODL sales, does not bar extraterritorial conduct, and does not bar sales that qualify for exemptions from registration. The court agrees that the SEC's proposed language is too categorical and, in any case, duplicative of behavior prescribed by Part 1 of the proposed judgment. The court will, therefore, omit the SEC's proposed Part 2. Finally, Ripple asked the court to waive the bad actor disqualification provisions of 23.506, which prevent an enjoiner issued from using the SEC's Regulation D exemption for certain private security offerings. Although the court has discretion to do so, Ripple cites no authority that persuades the court that judicial waiver is necessary or appropriate here. Accordingly, the SEC's request for injunctive relief is granted, and the court will impose a permanent injunction consistent with Part 1 of the proposed judgment. Disgorgement, legal standard. In addition to injunction relief, district court may also order disgorgement, which serves to remedy security laws violations by depriving violators of the fruits of their illegal conduct. Disgorgement is an equitable remedy, permissible only where it does not exceed a wrongdoer's net profits and is awarded for victims. Following Liu, the Second Court clarified the meaning of victims. There, the defendant caused his company to engage in 3 fraudulent security offerings, representing to investors that the company would use the proceeds from the transaction to satisfy the outstanding debts and for general corporate purposes. Instead, he diverted over $7.3 million of the offering proceeds to his own private accounts. The district court determined that disgorgement was warranted, reasoning that the defrauded investors were victims of the defendant's conduct because they were lied to, even if they may not have been financially harmed. The Second Circuit reversed, holding that a victim for purpose is one who suffers pecuniary harm from the securities fraud. The circuit explained that an equitable remedy is meant to restore the status quo in the context of disgorgement by returning the funds to victims, allowing defrauded investors who suffered no pecuniary harm to receive the proceeds of disgorgement. The circuit reasoned would confer a windfall on those who received the benefit of the bargain. Therefore, for purposes of ordering disgorgement, it is not enough that investors are lied to and thus denied the right to make an informed decision when considering whether to make an investment. Offending that right does not result in pecuniary harm. The parties dispute whether the circuit's decision in Govil bars disgorgement of Ripple's profits from institutional sales. The court finds that it does. The SEC contends that ordering disgorgement would not run afoul of Govil because Ripple's violation of Section 5 via entirely tainted transaction caused pecuniary harm to investors. Section Amendment at 17. Specifically, the SEC argues that Ripple sold XRP to certain institutional buyers at deep, undisclosed discounts, as high as banned at 18. Because Ripple failed to publicly register these discounted institutional sales, the SEC argues non-favored investors were deprived of the information they needed to determine whether Ripple was treating them worse and whether they could purchase XRP at a better price. The SEC estimates that if Ripple had disclosed its significant discounts to other investors, non-favored investors would have saved potentially more than blank. The SEC further contends that the discounted sales caused pecuniary harm by putting downward pressure on the market price of XRP, as investors who bought discounted XRP could sell for below market prices and still profit. Govil forecloses this argument. The SEC contends that Ripple appears to have not uniformly disclosed the desperate prices and discounts offered to institutional buyers. The circuit held, however, that the right to make an informed decision when considering whether to make an investment is not a property interest that can be vindicated through disgorgement. as Ripple argues, many of the gullible investors would have likely been dissuaded from investing, or at least valued the shares at a lower price, had they known that the company's founder intended to pocket the funds for his own use. Yet the circuit found that the pecuniary harm requirement was not satisfied, as the district court acknowledged that the investors received the return on the investment contemplated at the outset. Here, the SEC offers only speculative evidence that the institutional buyers did not receive the return on investment contemplated, noting that whether the investors actually suffered pecuniary harm would depend on the type of securities held, the terms of those securities, and when those securities were sold, a level of detail missing from the record in Gobble. The SEC's blank estimate of lost potential savings comes from an analysis conducted by SEC accountant Andrea Fox, who calculated how much less institutional buyers in the aggregate would have paid for XRP if the best price offered to institutional buyers had been obtained by every institutional buyer. But the SEC does not and cannot establish that Ripple would have, in fact, offered any additional discounts to investors had it complied with Section 5's registration requirements. It is possible that some investors could have demanded and potentially paid lower prices. Yet it is at least equally possible that Ripple would have opted to offer fewer and smaller discounts overall, explaining that unregistered shares are generally worth less than their registered counterparts. The fact that some investors may have been able to negotiate better deals if discounts offered to others were disclosed as required does not establish that they suffered pecuniary harm by paying the sticker price, noting that in fraud on the market cases, an inflated purchase price will not itself constitute or proximately cause the relevant economic loss. The SEC also argues that disgorgement is appropriate because Ripple's failure to disclose the discounts tainted each of the institutional sales. In Ahmed, the investment manager defendant stole over $65 million from his employer and 10 portfolio companies, including by negotiating transactions in which he had undisclosed conflict of interest. The Second Circuit found that the conflicted transactions were entirely tainted, holding that the defendant was obligated to disgorge the full amount he received. But the circuit's inquiry into permissible amount of disgorgement sheds little light on the threshold question here, whether the SEC has shown pecuniary harm at all such that disgorgement is warranted. In Ahmed, which the involved defendant's knowing misappropriation of millions of dollars from his employer, there were no questions that the employer had suffered an economic loss. Here, pecuniary harm is far less apparent. Because binding circuit precedent precludes disgorgement based on these facts of this case, the SEC's request for disgorgement and prejudgment interest is denied. Let me reread that again. Because binding circuit precedent precludes disgorgement based on the facts of this case, the SEC's request for disgorgement and prejudgment interest is denied. Like I said, I'm going to go back through all of this. I just really like that sentence. And so we're going to break all of this down. We're almost more than halfway done. Civil penalties, third standard of legal standard. The SEC is also authorized to seek the imposition of civil monetary penalties, which serve the dual goals of punishment of the individual violator and deterrence of future violations. Unsecured creditors of WorldCom, courts can impose penalties in civil injunctive actions not to exceed the greater of the gross pecuniary gain to a defendant as a result of the violation, or a specified amount per violation, depending on whether the violation falls in the first, second, or third penalty tier. A court may impose a first-tier penalty for any violation of the exchange if the violation involved fraud, deceit, manipulation, or deliberate or reckless disregard of a regulatory requirement, and a third-tier penalty if, in addition to meeting the second-tier requirements, the violation directly or indirectly resulted in substantial losses or created a significant risk of substantial losses to other persons. Because the term violation is not defined by the statutory scheme, courts have discretion to determine the unit of violation for the purposes of imposing civil penalties under the tier method. Although gross pecuniary gain or the tier determines the maximum penalty, the actual amount of the penalty is left up to the discretion of the district court. In determining the appropriate penalty, courts may consider factors including the egregiousness of the defendant's conduct, the degree of the defendant's motive, whether the defendant's conduct created substantial losses or the risk of substantial losses to other persons, whether the defendant's conduct was isolated or recurrent, and whether the penalty should be reduced due to the defendant's demonstrated current and future financial condition. Noting that the list is not exhaustive, noting that the circuit has not held the civil penalty for a securities fraud offense needs to be proportional to the disgorgement amount. The court also may consider the extent of which aspects of the relief and or judgment issued in this matter will have the desired punitive effect. SEC versus Universal application of this law. The SEC asked the court to impose a penalty of $876 million, actually $308,712, equal to the net profits it calculated for argues the penalty. Ripple argues that a penalty of no more than 10 million or about blank percent of Ripple's actual gross revenues from pre-complaint institutional sales is appropriate. So they did ban that out, but we know that to be 10% actually, because we know of Ripple's argument that they've made on this case publicly. They stated what their purpose was behind that. And so that motion that they posted out, they put it $10 million at I think it was like 3% of Ripple's actual gross revenues from pre-complaint institutional sales is appropriate. The court finds that a first-tier penalty is appropriate in this case, which involves no allegations of fraud, deceit, or manipulation, and no conclusively established or deliberate recklessness or disregard of a regulatory requirement. Although Ripple's gross pecuniary gain from the institutional sales sets a higher statutory ceiling, the court finds that the tier analysis method more closely tailors the penalty to the scope of Ripple's actual wrongdoings than the parties' virtually all or nothing requests. As to the amount of the penalty, the court has discussed the second and fourth Ragnatum factors, which overlap with the factors relevant to injunctive relief. Of the first factor, the egregiousness of Ripple's conduct, egregiousness of Ripple's conduct, there is no question that the recurrent, highly lucrative violation of Section 5 is a serious offense. However, this case does not involve allegations of fraud, misappropriation, or other more culpable conduct. Relatedly, as to the third factor, the SEC has not established that Ripple's failure to register the institutional sale causes substantial losses or the risk thereof to investors. And on the fifth factor, Ripple does not contest that its current financial condition does not merit a reduced penalty. Beyond the Rajaramantan NAM factors, the court considers that Ripple will not be ordered to pay disgorgement, which dictates in favor of a larger penalty to accomplish the desired punitive effect. The court finds, therefore, that a pre-violation penalty at the first tier maximum is appropriate. The final step is to define the violations involved in the institutional sales. Because Section 5's registration requirement is transaction specific, it follows that each unregistered transaction constitutes a separate violation of the statute. The SEC suggests that each of Ripple's 1,700 relevant contracts constitutes a separate violation. Ripple responds that the 1,700 relevant contracts figures include hundreds of contracts related to programmatic sales and other distributions, which should be excluded. Ripple does not offer its own tabulation of the relevant contracts, and the SEC does not respond to Ripple's contention in its reply brief. Based on the court's independent analysis of Ripple's expert report summarizing the relevant contracts, the court finds that 1,278 transactions violated Section 5, resulting in a civil penalty of $125,035,150. Accordingly, the SEC's request for a civil monetary penalty is granted in part, and the court will impose a penalty of $125,035,150. Conclusion. The SEC's motion for remedies in the entry of final judgment is granted in part and denied in part. The court shall enter a final judgment enjoining Ripple from further violations of the securities law and imposing a civil penalty of $125,035,150. The clerk of the court is directed to terminate the motions at ECF numbers 943, 948, and 951. Dated August 7th, New York, New York. So, that is the 16 pages, but what we are going to do here real quick, we're going to run through the footnotes just so we can sort of talk about what those were in part. And then we'll break down through this a little bit really quickly. Footnotes, Ripple has moved to seal certain documents filed in connection with the SEC's motion. The court will address these sealings requested by separate order. The court presumes familiarity with the facts and procedural history of this matter as detailed in prior orders, and therefore only summarizes those facts necessary for its decisions here. Capitalized terms not otherwise defined herein have meanings set forth in the order. Where else? So when they were talking earlier about ODL transactions, on-demand liquidity, where the SEC was saying that XRP was continuing to create ODL transactions, transactions facilitates cross-border transactions by allowing customers to exchange fiat currency, for example, US dollars, for XRP, and then the XRP for another fiat currency, for example, Mexican pesos. So what they're saying is that XRP is continuously getting used by people to transact cross-border payments from one currency to another, and that is why they are continuing to execute contracts. What a lot of what they didn't cover here is that a lot of those contracts that are set up are not actually XRP that have set those up. They're smart contracts that XRP monitors but doesn't really have any control over. And I think just monitorization over fraud alerts and stuff like that and AML purposes. Ripple notes that most of its ODL business is outside the United States, where contracts are governed by foreign law, and that Ripple now ensures that all new ODL customers have at least $5 million in total assets so that they are accredited investors under 17 CFR. Ripple oppositions at 7.8 citation omitted. Whatever merit these defenses may have, they are not determinative of the question before the court, whether the SEC has shown a risk of future violations. So, per that footnote, Ripple has pushed forward in signing new partners that are, what is that door? It's a frog. But what Ripple has set new precedent that everyone knew that it brings on has at least $5 million, so that they're accredited investors. What we know that Ripple and XRP have been doing, they've been bringing on institutional partners like banks for cross-border payments and settlements. And so that means even though they're meeting other countries' regulations, the only regulation truly in the US to be an accredited investor, there's many different ways you could be considered one, but as if you have $5 million or more in investments, you're considered an accredited investor. So if you go win the fucking lottery, you are now an accredited investor. You picked some numbers, you did the lucky pick, bam. You are now an accredited investor. You're considered smart money now. And so those are very antiquated US laws in my opinion. But yeah. So Ripple, the court agrees with the SEC that Ripple is towing the line and sort of pushing the envelope. So that is why they do find Ripple guilty in the civil parts of this case. 6 months after Liu, Congress enacted 78 UD7, which gives the SEC the power to seek and federal courts the power to order the remedy of disgorgement, SEC versus Gobble. The Second Circuit has interpreted to limit disgorgement to the bounds established by the Supreme Court's decision in Liu but SEC versus Hamlin, disgorgement is a legal, non-equitable sense. So not only has a lot of people have been talking about the Chevron deference overturning case and stuff like that, and the SEC not having full authority in this case. This hasn't been brought up yet as an argument in any way, shape, or form. It wasn't on the, on the table to be focused on, and so Ripple's attorneys have been really focusing on this. But then at the same time, one of Chevron's meanings is that if it hasn't been authorized by Congress, then it's not necessarily a standard. And so this does state that this has been authorized by Congress and followed up with by district courts. And so it's not just like SEC's playbook. So this is where the court is stating that it has the authorization and ability to order disgorgement. But because one, there was no fraud, or they weren't working under false pretenses, they weren't being dicks about it in that sense, Judge Torres found that they weren't doing anything wrong in that, or they were just doing it. They weren't trying to misrepresent or pull one over on anyone. So Ripple separately moves to strike Fox's declaration in supporting exhibits, arguing that they were filed late. ECF number, in light of the court's findings that no disgorgement is permitted, the motion is denied as moot. So what happened here, let's find this. So the SEC is trying to say the estimated loss of potential savings, constituted reasons for disgorgement. Ripple filed contested that, but because of the way, and so they filed a motion for that, but because the court found technically in favor of Ripple, the Ripple's countersuit trying to dismiss the SEC's motions for disgorgement, they found moot point. So it's like, I'm not going to make a ruling on something because there's no need to make a ruling on something. The SEC's sole authority to the contrary, SEC versus iFresh, is an unpublished district court opinion that found without analysis that the fact that stock prices were artificially inflated sufficient to establish pecuniary harm. That case, involving a consent order, required the district court to accept the SEC's allegations of stock price inflation as true. So the court didn't really take this in fact, which is sort of hilarious, because the SEC was trying to say that all of these investors were harmed. Every single one of them were harmed, and and they were harmed by this amount. And the judge said, Judge Torres says that basically, no. You don't have any proof that these people were harmed or that these people are unhappy about this. And that is true. From one of my last updates and stuff like that, there has not been any investor stepping up and saying, I was harmed because of this. I bought XRP at 0.002. And I am now unhappy that, I don't know, let's go look at where XRP is right now. I'm going to guess that it's like 63-ish cents. Oh, 60 cents. All right. It's up 17%, 17.93%. 45. So I don't think there's any investor that is upset right now if they bought it 0.002 or lower, or at a cent, or yeah. So the judge just sort of said, you're no. The amount on which a violator must pay prejudgment interest usually tracks the amount that the party has incurred order to disgorge. Since there was no disgorgement, there was no order to that penalty. And then lastly, 10, where is 10? So the civil penalty of 125 million. The court arrived at this figure first by tabulating the 1,278 sales contracts listed in Exhibits C of the expert's report, which excluded programmatic contracts, service contracts, and other contracts. Swartz report at 80 through 124. The court then determined the applicable penalty for each contract based on its date. Adjustments to civil monetary penalty amounts for contracts entered into on or after November 2nd, 2015, the penalty is currently $115,231 per contract. For contracts entered into between March 2013 and November 2nd, the penalty is $80,000 per contract. And for contracts entered into between March 4th, 2009 and March 5th, 2013, the penalty is $75,000 per contract. For the 4 undated contracts, the court applied the current inflation-adjusted penalty amount. Finally, the court totaled the pre-contract penalties to arrive at a civil penalty of $125,335,150. This sum is concededly an estimate of the maximum first-tier penalty. It is possible that the contracts listed in Exhibit C are either an incomplete or over-inclusive list of Ripple's institutional sales during the relevant period. Because neither party provided a more specific calculation, however, the court believes that its estimate is an adequate approximation. So because no one, countered anything, or Ripple countered the 17,000 contracts, but didn't say, in fact, here is the number. The court did their own homework on this. So I have been through this entire thing extremely interested with how much research Judge Torres does in all of this, and she does not leave a lot to chance. So huge shout out to Judge Torres for this. I personally find a few things missing out of this that not covered specifically by Ripple or the SEC that might find a little bit more in favor of Ripple. But on the institutional side of things, that is the main concern of where everything has been. So the fact that they have not been, what's the word I'm thinking of this? Because they haven't deep dive into trying to put out other pillars to take out from the SEC's wings. They've just been focusing on this. And that is a very strategic and good approach, because if you take that approach of throw everything at the wall and see what sticks, judges see right through that and they throw that out, or they just they don't have the time for that. So by being very specific, even if the SEC comes and they do a throw everything at the wall and see what sticks technique, judges know that too and see that as well. And so what in this case Ripple did is they looked for specific target pillars that, if you're looking at a building and, it has the keystone pillar and stuff like that, you can take out the keystone and the whole thing will crumble type of thing. That's where Ripple really, really attacked this case from. And they did a really good job with that. Does it go completely the way people would want it? No, but it is doing fairly well on this news over the last couple hours. And so wanted to just sort of bring this all to you, as this is some big news that's hit, but I wanted you to be able to hear everything. So the TLDR on this. So the case isn't over yet, because it's expected that both the SEC and Ripple will appeal this, but this is a motion for remedies, not a case closed type of thing. But the SEC's motion for remedies and entry of final judgment is granted in part and denied in part. The court shall enter a final judgment enjoining Ripple from further violations of the securities laws and imposing a civil penalty of $125,035,150. So there's 3 things. So basically 2 things there that's happening to Ripple. And so one of the things I wanted to cover real quickly is where we might have to go over this at a different time, but I wanted to just sort of talk about where Reg D exemption. So Ripple is asking for being excluded from bad actor consideration, so that they could possibly file for a Reg D exemption. And so that means they're trying to play by the rules that they know the SEC is going to try to, force them against. And so it's really interesting to see that they are still it's like they're still moving forward with trying to be, registered and do the paperwork, and they're getting denied that opportunity. Over the next couple of days, we're going to try to reach out to some of our really good friends like John Deaton and Eleanor Terrett to sort of get a breakdown of this a little bit and have some fun talking about this. And so we hope that you've enjoyed this. This has been a long time coming. And want to thank everyone for joining in on this. This is, one of those big days. So the market's been responding a little bit well to this. Solana's at $153, not tied to XRP in any way, but maybe you might want to look at Root and Asta and see what's going on over there, as they are really doing a lot of things with XRP as well. So we hope you like that. And we hope you like this episode of TacoBytes, your daily bite of Degen, episode number 714. I want to thank everyone from LinkedIn, Player One Taco YouTube, 0xDegens YouTube, Twitch, Twitter, Telegram, Rumble, Kick, Unlonely, On-Chain via Base, and Soul Media Tech via Solana for tuning in tonight. We hope to see you tomorrow. Please like, subscribe, comment, just for the heck of it. Help me out in some way, shape, or form. We would really appreciate that. But in the meantime, we end this episode with the same two things we leave every episode: our words of wisdom and the greatest, worst knock-knock joke on the face of the planet. And our words of wisdom are always the same. I don't know why I put my hand up like this. It seems weird, but I'm going to do it anyways. A closed mouth cannot be fed, and you cannot feed a closed mouth, meaning if no one knows you're looking for opportunity can never come knocking. If opportunity does come knocking and no one answers, it's going to keep on walking. And with this, we want to wish you all a great night and a great morning and a great afternoon. And we will see you next time. And as always, we end with the greatest, worst knock-knock joke on the face of the planet, and that is knock-knock. Who's there?